Good afternoon, everyone. Welcome to Booth Auditorium at Berkeley Law School. My name is Jeremy Fogel. I am the Executive Director of the Berkeley Judicial Institute, which along with the Bolch Judicial Institute at Duke Law School and the American Bar Association litigation section, is the sponsor of this series on the Supreme Court. I'm going to say a few words about the series. I'll introduce our panelists, and then I'm going to get out of the way. We have a very large audience online. I'd like to welcome all of those people for being with us today. For those of you who are in the room, we will be taking questions on index cards, which you picked up when you came in, and we'll have time for questions after the panel has had a conversation. So this project of the litigation section of the American Bar Association is meant to look at the impact of Supreme Court decisions on the life of our country, the life of our society. That's a big topic, and it covers a lot of different areas of life. Next week, there will be a program in Washington, D.C., in which the panel will talk about voting rights and the impact of Supreme Court jurisprudence on voting rights. And there are going to be other similarly important topics talked about during the remainder of the series. But to get the series started, we thought it would be very helpful to have a historical session, one where we talked about the current Supreme Court and where it fits in the history of the Supreme Court as an institution. Is it an outlier, or is what's happening with the court now simply part and parcel of the ups and downs and the ins and outs of the historical trends that have affected the court? We have a really terrific panel to discuss that issue. And I'll introduce them in alphabetical order, because that's as good a way to do it as any. First, Professor Jonathan Adler from Case Western Reserve University in Cleveland, Ohio. He is a leading conservative/libertarian scholar. He's done a lot of work on healthcare, environmental law. His specialties are constitutional law, administrative law, jurisprudence, and environmental law. I think he's just an excellent exponent of one side of this conversation. And Professor Adler, thank you for making the trip. In the middle is Erwin Chemerinsky, who is the Dean of Berkeley Law School, among many other things. And he is a leading liberal scholar of the Constitution and of administrative law. One interesting fact about Erwin is that he was identified as perhaps the most influential legal educator in the United States, and one of 23 law professors you should take before you die. There's a lot to say about Erwin, but I'll just stop there. And Erwin, thank you. I know how hard it is for you to find time to be with us. And then it's my special pleasure to introduce Justice Carol Corrigan from the California Supreme Court. And I'll just say as a point of privilege that we've known each other more than 40 years. And we started out together in a job that doesn't exist anymore, which is municipal court judges. Justice Corrigan has served at every level of the California judiciary and has been on the California Supreme Court for 19 years, having been appointed by Governor Schwarzenegger. And I thought she'd be a great moderator because she has lots of opinions, but she is a moderate person. She's somebody who really thinks things through, and I think will lend some gravitas to this conversation. So without any further ado, Justice Corrigan.
Thank you, Jeremy. Good afternoon, ladies and gentlemen. We're so pleased you could be with us for this conversation. For the people in the room and for the people in the ether, we're happy to have all of you with us. We have much to discuss and two distinguished scholars with whom to discuss it. So we also want you to be part of the conversation. For those of you in the room, as you heard, and as you know, you have your little cards. If you have questions, please just hold them up and someone will come and get them. For those of you on Zoom, you can someone will be monitoring the chat room, so you can participate in that way. As you have heard, our main task for our time together is to talk about the current Supreme Court and its jurisprudence and how different or not. That may be from their predecessors on the court. This is not the first court to live through yeasty periods in American history. And we all thought it would be helpful to have some historical context, because when you're living in interesting times, it can be tempting to think that this is the first time anything like this has ever transpired in the history of humankind. So our task is somewhat historical, and the focus is this court really different? Or is it just a court reflecting its own times? Opinions may differ. So let's begin with you, Erwin, and have your take on it.
Thank you. It's really an honor and pleasure to be part of the conversation. In my role as Dean of the Law School, I want to thank Justice Corrigan, Professor Adler for making the trip and being part of Berkeley Law. I think there is an analog to the current Supreme Court. It's found in what we commonly refer to as the Lochner Court, which existed between the mid-1890s and 1936. During that time, a very conservative court struck down over 200 federal, state, and local laws. What's similar to now, it was a court following a conservative ideology of the justices, not following precedent, not following a neutral methodology, and in fact, whatever methodology they had was a quite undesirable one. 25 years ago, I wrote the first edition of a constitutional law casebook. Last fall, I finished the 7th edition. I've never done a new edition where so much changed from the prior edition or from all the prior editions. Think of what's happened just in the last 2 years in the United States Supreme Court. The court's overruled Roe versus Wade. The court's dramatically expanded the scope of gun rights. The court's imposed significant new limits on the power of administrative agencies. The court, for the first time, has held that a public school teacher has a First Amendment right to pray at a public school event. The court's effectively overruled 45 years of precedent that allowed college, university to engage in affirmative action. And the court, for the first time, held that a business establishment has a right to violate state anti-discrimination laws when it's engaged in expressive activity. I want to make 3 points today, and I'll tie each back to the Lochner Court. First, the current court has no respect for stare decisis precedent. Second, the court's not following a neutral methodology like originalism. Third, to the extent they are following originalism, it's a highly undesirable methodology. And the inescapable conclusion is all that explains what the current court is doing is much as the same that explains what the Lochner Court was doing, following the very conservative views of the majority on the bench. Well, the first thing isn't obvious. This is a court that has no respect for precedent. On June 24, 2022, the Supreme Court in Dobbs versus Jacksonville Health Organization overruled Roe versus Wade. Roe at that point was a precedent that was 49 years old. As the dissent powerfully said, there was no basis for overrule in terms of it being impossible to administer in practice. There had been enormous reliance on the time. All that had changed was the composition of the Supreme Court. There were other instances that term where the Supreme Court overruled precedent. I alluded to Kennedy versus Bremerton School District, the case where the Supreme Court said that a public school teacher had a First Amendment right to pray at public school events. Justice Gorsuch, writing for the majority, said that Lemon versus Kurtzman had been overruled. This was a 1971 Supreme Court case that had articulated the test when the government violates the Establishment Clause. Or another example from June 29th of last year, when in Students for Fair Admission versus President and Fellows of Harvard College, the Supreme Court effectively overruled 49 years of precedent that allowed college university to engage in affirmative action. Stare decisis matters because it provides predictability, stability in the law. There should be a reason for overruling a precedent other than just the current majority ideologically disagrees and would come to a different conclusion. But this is much like what we saw with regard to the Lochner Court. From 1787 until the 1890s, not one federal law was struck down as exceeding the scope of Congress's commerce power or violating the 10th Amendment. And then the Supreme Court during the Lochner era struck down many federal laws In fact, it invalidated the first federal child labor law that led to many children being maimed and dying. With regard to substantive due process, never in the 19th century did the Supreme Court say that the government is limited in its ability to regulate contracts. But the Lochner era struck down so many laws, minimum wage laws, maximum hour laws, consumer protection laws to protect workers. My second point is that the decisions of the Roberts Court can't be explained by a neutral methodology such as originalism. To be sure, there's at least 3 justices on the current court who describe themselves as originalists: Justices Thomas, Gorsuch, and Barrett. But what's so striking to me is that this is a court that abandons originalism when it doesn't get the results that it wants. Take, for example, Students for Admission versus President Fellows of Harvard College. The same Congress that ratified the 14th Amendment adopted so many race-conscious programs that today we would regard as affirmative action. Things like the Freedmen's Bureau, things like benefits given solely to Black individuals who are veterans. Yet you find Chief Justice Roberts' majority opinion paying no attention to that originalist history because it doesn't get to the conservative result they want. This has been characteristic of other decisions of the Roberts Court. Take Shelby County versus Holder from 2013. Terrible decision where the court struck down a key provision of the Voting Rights Act that required the state and local governments get pre-clearance before they adopt new voting procedures if they have a history of race discrimination. Chief Justice Roberts' majority opinion said that this violates a principle of equal state sovereignty, that Congress must treat all states the same. I challenge anyone to find in the text of the Constitution anything about equal state sovereignty. In fact, again, the Congress that voted for the 14th Amendment imposed Reconstruction on southern states, military rule governed by generals. Harder to think of anything that's more violative of equal state sovereignty. Or a bit earlier in the history of the Roberts Court, take Citizens United versus Federal Election Commission, where the Supreme Court held that corporations have the right to spend unlimited amounts of money to get candidates elected or defeated. Corporations, we know them now, didn't exist in 1791, but certainly campaign finance, as we know, didn't. But that didn't keep the Roberts Court from striking down key provisions of the McCain-Feingold Bipartisan Campaign Finance Reform Act. My point is that the court follows originalism if it gets to the conclusion it wants and ignores originalism when it doesn't. This is similar to the Lochner Court. It followed its methodology when it liked the results and ignored it otherwise. And so the Lochner Court was willing to strike down a federal law that prohibited the shipment in interstate commerce of goods made by child labor, but it upheld the federal law prohibiting shipment of lottery tickets in interstate commerce, saying lotteries are a pestilence. It didn't regard child labor as a pestilence. It prohibited the shipment in interstate commerce of obscene material, but wouldn't allow Congress to prohibit the shipment of interstate commerce of material made by child labor. Like the current court, it was a group of justices who followed conservative ideology when it came to the results they wanted and ignored it otherwise. My third and final point is, to the extent that the Roberts Court is originalist, originalism is a terrible way to approach the Constitution. It makes no sense for us to be governed today by the views of those in 1787, when there was an agrarian slave society. In fact, we're not going to find answers today for most constitutional issues from what was the practices in the law then. In Kennedy versus Bremerton School District, in talking about what violates the Establishment Clause, Justice Gorsuch says, the line is to be drawn based on, and I quote, the views of the founding fathers. Ask yourself this: what did the framers of the First Amendment think about a high school football coach at a public university going on the field and praying after games? Just asking the question shows the absurdity of originalism. One of the most tragically wrong decisions of the current Roberts Court was the New York State Rifle and Pistol Association versus Bruin on June 23rd of 2022. There, the Supreme Court found a right of people to have guns in public, but even more tragically, Justice Thomas, writing for the court, said the only kind of gun regulations we allow now are those that were historically permitted meaning 1791 or maybe 1868. We live in such a different country now. Population density is different. Most of all, weapons are different. There weren't AR-15s or large capacity ammunition magazines in 1791. To see why originalism is so flawed, I can simply say Brown versus Board of Education, Loving versus Virginia, Obergefell versus Hodges. None of those could be justified under originalism. As to Brown, the same Congress that ratified the 14th Amendment also voted to segregate District of Columbia public schools. In terms of Loving versus Virginia, the majority of states had laws prohibiting interracial marriage in 1868. California didn't eliminate it until your court in 1948 found the California law prohibiting interracial marriage was unconstitutional. It wasn't until 2015 that the Supreme Court finally recognized equal dignity for gays and lesbians to be able to marry. None of those could be justified under originalism, and any methodology that makes those decisions illegitimate should be rejected. Again, there's a parallel to the Lochner era. The Lochner era decisions couldn't be justified from the perspective of originalism. There's nothing in the Due Process Clause that protects freedom of contract. There's nothing in the Commerce Clause that says that Congress can't use its power to regulate commerce among the states, prohibit shipment interstate commerce, things made by child labor. It was just a court following the ideology of the justice on the bench at the time. Our country is more politically divided than it's been any time since Reconstruction. I think the crucial underlying question is, what will it mean for the country to have a court that's so far to the right on one side of the divide when the country is so split? We saw what happened in the 1930s to the Supreme Court. It lost its legitimacy. I fear that's where we're going right now.
Jonathan, you have spoken and written widely on this topic. Do you see it through the same lens?
Not exactly. But first, let me say it's an honor and a pleasure to be here with Dean Chemerinsky and Justice Corrigan and to be part of this conversation and to be able to talk about this important topic. And so I certainly appreciate being here. Dean Chemerinsky and I certainly agree on a little bit. We agree that the country is terribly divided today. We agree that the court is certainly a more conservative court than we've seen in some time. And we certainly agree that the role of the court in our politics is a very important one. Beyond that, I think that some of the agreement begins to break down. Certainly the court is more conservative than we've seen in the post-World War II period compared to the American public. Through most of that period, it'd be fair to say that the court was on most issues near the center of American political opinion or slightly to the left of center of American political opinion. And one can look at public opinion polls throughout the past 70 or so years and see that pattern consistently held true. And that is certainly not the case anymore. And I'll talk a little bit about the importance of that and what that might mean going forward. I think the other thing, though, it's important to understand about this court looking at the post-World War II period is that it's also a significantly more conservative court prudentially and in terms of its behavior, not merely in terms of the substance of its judicial decisions. And I think that often gets lost when we're talking about the role of the court in American society. This is a court that, as a general matter, is at least attempting to do less than we've seen a Supreme Court try and do over the past 75 years, 80 years. Just to start, it's deciding fewer cases, a lot fewer cases. This term, it's hearing 61 cases. And as we know, some of those cases weren't cases that arose in the normal course and that the court wanted to take, such as the Trump immunity case that will be heard on Thursday, or the case challenging whether Donald Trump can run again for president that came out of Colorado. So even with those cases that were thrust onto the court's docket, the court's only hearing 61 cases. When I was in law school, the court would hear double that. We can remember periods in the 1980s, for example, where the court would hear arguments and decide over 150 cases per term. So it's deciding less, and it's largely choosing to do so. Because one thing that's certainly different than the court historically is the overwhelming makeup of the court's docket is what we refer to as the certiorari docket, the cases that the court chooses to take because it grants petitions for certiorari, usually because there is a division among lower courts or among high courts in the states, or because a federal statute has been struck down. And that is the vast majority of the court's cases. There used to be a larger share of the court's docket that were what we referred to as the appellate jurisdiction, cases that the court was effectively obligated to take. We don't see very many of those anymore. One or two cases where states are suing each other over boundaries or water or something like that. Occasionally, cases involving sometimes elections and the like where Congress has maintained appellate jurisdiction. And I think one area where Dean Chemerinsky and I might agree is that it would probably be better if the court took more cases. If for no other reason than there are more circuit splits than the justices seem being willing to resolve. I would also argue that the way we perceive the court would probably be different if the court were taking more cases, because the increased number of cases it would be taking would be more of the kind of bread and butter of legal practice and appellate practice. And these may not be cases that excite the clerks when they're in the cert pool reviewing the cert petitions, but these are the sorts of cases that are why we have a Supreme Court, to help ensure consistency and uniformity federally, and that would be something for it to do. But I don't think that the shrinking docket is an accident. I think it's something that I think at the very least reflects the philosophy of the current Chief Justice, if not other justices, that the court should try and do less. We all remember when John Roberts was before the Senate Judiciary Committee, he talked about how he saw judges as umpires calling balls and strikes. And we had a lot of discussion about whether or not judging is really like calling balls and strikes, and acknowledging, of course, that different umpires have different size strike zones and evaluate different sorts of pitches in various ways. We could, for those of you that are NBA fans, we could talk about the reffing of NBA games and playoff reffing versus regular season, and draw those analogies as well. What I think is the part of what John Roberts said at the hearing that was missed is I don't think the important part of what he said was about balls and strikes. It was about the notion that if after a game we're talking about the umpires, we're not very happy or satisfied with the game. And I do think that is the current Chief Justice's view of the role of the court. If we're talking about what the court did in our politics, as opposed to what those we elect are doing and did, that's a problem. And so I do think a lot of the broader trends we see in the court are a reflection of his effort to have the court try and recede into the background. Now, whether or not that's possible, whether or not that's fully desirable, we can set those aside for the moment. I do think in terms of understanding the court's behavior, I think that's an important thing to notice. Now, in terms of areas where Erwin and I think disagree more sharply, I think one is just describing what we've seen since John Roberts has been Chief Justice of the court. So let's start with precedent. The Supreme Court certainly overturns precedents. It does so almost every term. On average, 1 or 2 precedents per term since John Roberts has been Chief Justice. What's interesting is that rate at which precedents are being overturned, or in which opinions call into question or undermine prior precedents, is lower under John Roberts than under any other post-war Chief Justice, and it's not close. I've done this work. I've done some work with Adam Feldman, who runs Empirical SCOTUS. There are multiple data sets with which one can look at this. The Supreme Court database that's maintained at Washington University, the data sets that are put together by the Library of Congress. Under all of them, we see the rate at which precedents are overturned is lower under John Roberts than it was under Chief Justice Rehnquist, under Chief Justice Berger, under Chief Justice Warren, and again, it's not close. Depending on which data set we use, we see the number is about 1.5 per term under Roberts. It was over 2 under Chief Justice Berger. It was 3 to 4 per term under Justices Warren and Berger. The age of precedents is no older. There are no older under Chief Justice Roberts than under prior Chief Justices. And that's actually a surprise, right? Because there are more precedents to overturn, and there are more older precedents to overturn the more time goes on. And yet the age of precedents that are challenged or overturned is not going up, and the rate at which precedents are being challenged or overturned is actually going down. Are the cases that are being overturned more important? Maybe, but that probably depends on what you think is more important. Is Dobbs overturning Roe more or less important than Lawrence overturning Bowers versus Hardwick? Is it more or less important than, say, Wayfair overturning Quill? Now, some of you might not know or remember Wayfair, but this is a case that affected every American because it's what allows states to collect taxes on internet sales from vendors that aren't in their state. That was a 5-4 decision overturning a precedent that affects each and every one of us every time we purchase something online. It was something that was heavily debated. So it's not just that cases like Dobbs or Students for Fair Admissions that overturn precedents. There are lots of other ones, and it's happening less often than it used to. In terms of statutes, we can also measure the court in this regard. How often does the Supreme Court conclude that the enactment of a legislature is unconstitutional? Here again, we see the Roberts Court doing that less often than did the Rehnquist Court, the Berger Court, or the Warren Court. Now note, with precedents and with statutes, I'm saying nothing about whether or not any individual decision to either overturn a precedent or invalidate a statute was good or bad, because that's a separate question. But just in terms of the frequency with which the Supreme Court is unsettling expectations, is overturning precedent, or holding what legislatures did to be unconstitutional, it is doing it less often. In terms of statutes, the court that did this most often was actually the Berger Court. And if we just want to isolate this to federal statutes, the court that did this most often was the Rehnquist Court. But the Roberts Court lags by both measures. And I think when one looks at when the court does overturn statutes, we also see a court that often is reluctant to do so. So the case of Shelby versus Holder, for example, was preceded by a case called Nabudno, a prior challenge to the same portion of the Voting Rights Act, where every justice on the court acknowledged that there were serious constitutional concerns about the way Congress had been exercising this authority and its failure to update the formulas that determined which states had to go through pre-clearance or which jurisdictions had to go through pre-clearance. Congress was given ample opportunity to update that statute, and it didn't. And only after that did the court ultimately strike that down. And we see that pattern repeatedly, the court using doctrines like constitutional avoidance to avoid invalidating the acts of legislatures. Congress in particular, if it thinks it can avoid doing so by altering its interpretation of the statute. Now again, some of those decisions on the merits we might not like. I've been very critical of some of the decisions where the court adopted strained interpretations of legislative text to avoid declaring statutes to be unconstitutional. But in terms of the role of the court in our political system, the fact that the court goes out of its way to avoid declaring what Congress has done to be unconstitutional does say something about the way the court is acting and the leeway it gives to legislatures to address policy questions that matter to us. And if we're concerned about the dead hand of the past controlling what we do today, we want to give legislatures a wide berth to reflect contemporary values as opposed to the values of 100 or 200 years ago. Make two other short points. One area where we do see the court being more aggressive is certainly pushing back against executive power. But this is not new with the Roberts Court. In fact, it's a long-term trend, and it's a trend that some folks might find to be quite positive. During the New Deal era, the court was incredibly deferential to executive power. So we see this in cases like Chenery 2, for those of you that are interested in administrative law, and we see a dramatic change in the approach towards agencies between, say, SEC versus Chenery 2 to West Virginia versus EPA. A very dramatic change in how much leeway agencies are given. But it's not confined to administrative law, because over that same period of time, we see a dramatic change from, say, ex parte Corrigan or the Korematsu decision, where the court was exceedingly deferential to the executive branch in the conduct of war, to an early Roberts Court decision, Aboumediene, which is, without question, the most aggressive exercise of judicial review over a national security measure during a time of armed conflict in our nation's history. Now, is that a good thing or a bad thing? My own view, it's probably a good thing. That overall trend is a positive trend, but a trend of pushing back against executive power is consistent with this view of giving legislatures more leeway to address problems as they arise. Last point I'll make is, as I mentioned, it is a conservative court. It's a more conservative court than we're used to. It's also a 6-3 court. As we often think about. And that may mean that some of the things I've said about the past trajectory of the court and the Roberts Court might not hold going into the future. There are certainly reasons why we might expect the court to begin to become more aggressive, for example, at overturning precedents than it has been thus far. And if so, that'll be worth noting, and if it's a problem, worth pushing back against. But thus far, we have not reached that point. The other thing about it being a conservative court is we've seen periods of time before where a majority of court was assembled by individuals that were concerned about particular sorts of questions that come before the court, building a large majority on those questions. We certainly saw that during the New Deal. But what we also saw is that as times changed and the issues that we put before the courts changed, what had been a monolithic block of basically the entire Supreme Court appointed by Franklin Roosevelt splintered when the issues were no longer about the constitutionality of the New Deal, but they were rather about criminal procedure, civil rights, federalism, and other questions. And we're beginning to see the same thing already on the current court. The justices that are monolithic when they're focused on the questions that have dominated policy debates and judicial debates for the past 50 years, like abortion or affirmative action, splinter when the question is, how do we apply things like the First Amendment and the authority of the government to regulate what might be common carriers when it comes to the internet? Or how do we approach questions like preemption? Or how do we approach questions like the Dormant Commerce Clause? These are very important questions. And the conservative justices that we think of as being a block on a question like abortion are anything but on these emerging questions. And I think that's something we will see going forward. I'm sure I've given Dean Chemerinsky plenty to disagree with, so I will stop there.
Okay, so I'm going to take us in just a slightly different direction, but I think it'll give you plenty to work with. Retired Justice Stephen Breyer was on television this weekend talking about his new book, Reading the Constitution. And he said some very interesting things, but he said one really remarkable thing. He said, "I've never seen politics influence the court's decision-making." This from a man who sat on Bush v. Gore and recently wrote a dissent in Dobbs v. Jackson. And he quoted constitutional scholar Paul Freund by saying, "No judge should or will be moved by the temperature of the day, but every judge will be aware of the climate of the season." So what's your take? Is this we're all above politics thing just a story that justices tell themselves? Or do they, and are they willing to set aside public opinion or even their own opinion when deciding cases of substantial moment? What do you think, Jonathan?
Well, so I'm asked this question by my students all the time, and what I answer this is that I think the vast majority of judges, the vast majority of the time, do their level best to answer the questions before them based on the relevant legal authorities and the arguments that are put before them. But there are, of course, two important qualifications there, right? Sometimes the relevant legal authorities run out. This term so far in the Supreme Court, the court has decided 14 cases, 12 of them are unanimous. It's the highest rate of unanimity through April that we've seen in decades. And what's remarkable to me is that not how often the court splits 5-4 or 6-3, but how often it's unanimous, because the only cases it's taking are cases in which really smart lower court judges have disagreed when they've heard arguments from really, really smart advocates. And yet the court answers a lot of them unanimous. That I think is evidence that in the vast majority of the time, they're trying to answer the question based on the relevant legal authorities as best they can. But the legal authorities sometimes run out, which means the underlying judicial philosophies are going to necessarily have a role in those cases. The other qualification I would add is that judges are people too. And what I mean by that is that when you put, and in the first year, some of my students take a little time to get over this. They just want to say, well, the court said it, must be right, but I have to work on them. But what I mean by that is, when you put on a robe, it doesn't suddenly immunize you from all of the cognitive biases and all of the ways motivated reasoning or other things can affect decision-making. One of the reasons we have multiple judge courts at the appellate level is to help protect against that, because the idea is that discussion and back and forth can be at least a partial check on that. And what we've known as research on things like motivated reasoning has gotten better is that it turns out the smarter you are and the better you are at crafting arguments, the better you are at convincing yourself at the thing you shouldn't actually be convinced of. And so it would be naive to say judges are never affected by their priors, are never affected by their desired outcomes. because they're people, and we all are affected by such things. But I do think the vast majority of the time, they are certainly attempting to not do that. And if we want to predict their behavior and make arguments before them, I think we have to approach it that way, right? You can't go into court and say, Your Honor, well, because these are your politics, this is how you should decide for my client. Or I think the Supreme Court did this for this political reason, so you, district court judge, should decide this way, right? We can't structure arguments that way. So I think we should agree with the underlying statement, right? That judges are trying to avoid doing politics, but recognize that there will be instances in which the political consequences, the judge's priors, are certainly going to influence the way they see cases and the way they ultimately decide.
I saw a little head shaking.
So I apologize. I don't mean to do that. But I do disagree. I think it's important to draw a distinction between politics and ideology. In one sense, the Supreme Court is not political. There's no indication that the justices trade votes with one another as a legislature might. There's certainly no ability to go and lobby a justice or a judge in the way it's completely acceptable to go and lobby a member of city council or state legislature or Congress. But the decisions of the Supreme Court now and always have very much been a product of the ideology of who's on the bench. Marbury versus Madison wouldn't have come out the way it did if not for John Marshall and his views about the powers of the judiciary. I talked about the Locke era. The Supreme Court's conservative decisions in the 1890s, 1936, were entirely a product of who was on the bench. The Warren Court's liberal decisions were a product of who was on the bench. And the current court's decisions are a product of who's on the bench. We shouldn't pretend it's anything else. Ask yourself the following. What would have happened if Hillary Clinton had won in 2016 and she had picked 3 justices rather than Donald Trump? Now I'll go back through the examples I mentioned in my introduction. Roe versus Wade surely would not have been overruled. The court would not have expanded gun rights and might have even greatly limited gun rights under the Second Amendment. The court not have created the new limits on administrative agencies like the major questions doctrine. The Supreme Court would not have found that a public school teacher has a First Amendment right to pray at a public school event. The court would not have overruled the affirmative action cases as they did last term. And the court wouldn't have found that a business had the right to violate state anti-discrimination laws. It's not coincidental that every one of those cases was a 6-3 decision. The only difference in Dobbs, Chief Justice Roberts didn't want to go all the way in overruling Roe versus Wade, but it's still 6-3 in result. It's not coincidence that the 6 conservative justices have come out this way, and the 3 liberal justices came out the other way. And if Hillary Clinton had picked those 3 justices, those cases would have been 6-3 the other way, though likely they would never come to the Supreme Court at all. The Supreme Court's decisions in these kinds of cases are entirely a product of who's on the bench and what the values are of these individuals, and we shouldn't pretend to be anything else. In terms of the 14 cases this term, you can use statistics in lots of different ways. The reality is it's rare for the Supreme Court to have only decided 14 cases to this point. So to say there's been a lot of unanimous cases, there also haven't been very many decisions yet. Let's talk about number of 6-3 decisions when we get to July 1st at the end of the term, not at this point in the term. And of course, I agree, how you argue to a court is different than how you appraise the court. Of course, when I appear as a lawyer, I'm making the strongest arguments I can. I'm teaching constitutional law this semester. I'm teaching my students how to argue to the judges and justice they'll be before. But they can't ignore, I can't ignore, none of us can ignore who the judges are and their values. And in the vast majority of kinds of cases we're talking about, it's their values that determine how they rule.
Well, all right. So the United States Supreme Court has recognized fundamental rights that are not explicitly mentioned in the Constitution. But it has also articulated, in any event, a limiting principle. And they say that it hesitates to recognize new rights unless they are deeply rooted in our traditions and history. But history evolves, and it continues to shed light, and traditions change. So how do judges navigate those waters? Must they wait until public opinion has manifestly changed? Or can they act to accelerate change by declaring that the public view has changed? Where's the balance between ordered evolution and what Justice White has called the raw exercise of judicial power? What do you think, Erwin?
I think saying that the court's limited to its deeply rooted in tradition would be terrible now, would have been terrible previously. If that's what the Supreme Court does, then Brown versus Board of Education was wrongly decided. Because after all, prior to Brown versus Board of Education, Plessy versus Ferguson was the law for 58 years. In fact, the tradition in the United States is as much about racism and sexism and homophobia and anti-Semitism as it is about equality. And so we can't tie constitutional law and shouldn't tie constitutional law to the values of a long ago time. Now, your question specifically focuses on fundamental rights. The reality is, since at least the 1920s, the Supreme Court has recognized the need to protect rights that aren't enumerated in the text of the Constitution. Think about them. The Supreme Court has said that the right to marry is a fundamental right. The court did that in 1967 and reaffirmed it in Obergefell in 2015. The right to procreate, Skinner versus Oklahoma in 1942. The right to custody of one's children, Stanley versus Illinois, 1972. The right to keep the family together, Moore versus City of East Cleveland, 1976. The right of parents to control the upbringing of their children, Meyer versus Nebraska, 1923. Pierce versus Society of Sisters, 1925. The right to purchase and use contraceptives, Griswold versus Connecticut, 1965. The right of competent adults to refuse medical treatment. You can find that earlier, but certainly at least in Cruzan versus Director of Health Services, 1990. The right of consenting adults to engage in private, consensual same-sex sexual activity, Lawrence versus Texas, 2003. Or what about outside of due process? Freedom of association, NAACP versus Alabama, 1958. I can give many more examples. If we say that the only rights that are protected are those in the text or original meaning or a long tradition, then all of those rights become suspect. That's what's so scary about Justice Alito's majority opinion in Dobbs. He says that the only rights that you've protected are those that meet the criteria you described. Then all of the rights that the court has protected become illegitimate.
So let me say a couple things. First, I think I disagree on that last point. I don't think that all of those rights become illegitimate under Justice Alito's articulation in Dobbs. But I think we should step back on this question for a moment. First is that one reason we have a constitution, one reason we have a written constitution, is to constrain the choices of political actors, to constrain legislatures, to say that a political majority can't necessarily do what it wants. And the problem that we always face is, when is it legitimate for judges, especially federal judges who are not elected, to decide that what the people's representatives have sought to do can't be done? And there's a tension between, on the one hand, complaining about Supreme Court striking down statutes. Dean Chemerinsky gave some examples earlier, but then say, well, but we want the Supreme Court to strike down more statutes because of these fundamental rights that we believe are important today that maybe those that came before us did not see as all that important. It's a tension that's built into our system, but I think it's important that we recognize that that's part of what we're dealing with. When and under what warrant does a group of individuals who were not elected have the authority to say that those who we elect can't enact laws consistent with our values and preferences? Now, in terms of my own views, as you know, someone that thinks of himself as a classical liberal or a libertarian, I would like the Supreme Court to recognize far more rights as a matter of my policy preferences, in terms of the things that I can do with on my own, with my family, with my property, and so on. But I'm not convinced that the Constitution embodies that political ideology any more than it embodied Herbert Spencer's social statics, any more than it embodied a lot of the views of the Warren Court or the Burger Court in terms of what things should be taken off the table for political majorities. What the Supreme Court said in Dobbs, in effect, was we've gone too far as a court in taking things off the table from the political process. That's the dominant criticism that was made of the Lochner Court at the time, the dominant criticism that was made of it in the New Deal era. The dominant criticism that was made to move away from that was that the court had been taking too much power for itself rather than leaving it to the political process. Right? A case like Obergefell, I'm very happy that that became the law of the land in terms of allowing for same-sex marriage to be recognized on equal terms and with equal dignity as opposite-sex marriage. That was a policy view I had held for decades before the Supreme Court got around to it. So as a policy matter, I'm really happy about that. But as a jurisprudential matter, we should say to ourselves, how do we have a court that has the authority to do that if and when political majorities don't support that outcome, that doesn't also say the court gets to override political majorities when it happens to have a majority that doesn't share my policy preferences. Because you really can't have one with the other, right? Without the other. You can't say, I only want a court to be declaring fundamental rights that are important to my political coalition, but the other political coalition, when it has a majority, can't do the same thing. The choice is whether we have a court that leans in to that process and says, yes, we're going to limit the power of legislative majorities when our political coalition has control of the court, or we're going to have a court that's much more reluctant to do that. And then the question is there a neutral tether, a neutral anchor that can at least identify some set of situations in which it is legitimate for the court to override what political majorities want to do? Certainly, the constitutional text is one such tether. The argument in Dobbs, which we saw previously in Glucksberg, which we saw in one of the concurrences in Griswold, is that history and tradition might do that as well, because we might be able to identify questions that were so fundamental to our lives as free individuals that we'd never even thought they would be a question for the government to intrude into, or politics. And maybe that can serve as a neutral tether too. But the whole inquiry there is to find something that is not the judicial ideology of the judges to decide which questions the legislatures get to be involved in and which ones they don't. And I think it's hard for us to say simultaneously, the court is being too aggressive here, but the problem is it's not being aggressive enough unless all we expect of the court is to embrace a particular political ideology. In my own view, that's not primarily what we want federal courts for, and not the role we want the Supreme Court to be mostly engaged in.
Of course you can. It's your law school.
That certainly left me speechless to think of that. Certainly my students, staff, and faculty don't think of it that way. My point is that it's all about the value choices that are made. And what explains the current court, like explains the Lochner court, isn't some neutral methodology, but the values of the justices. In terms of the Lochner court, I think the primary problem with the Lochner court was the value choice it made. It did not think the legislature should have the ability to equalize bargaining power by setting things like minimum wage and maximum hour laws. And the court said that repeatedly. In a society with tremendous inequality in wealth, we should allow the legislature to do that. In terms of what you say, well, we want a restrained court, that doesn't explain the Roberts Court. I mean, if we thought of the Roberts Court as restrained, then how come it's the first in all of American history to strike down any laws as violating the Second Amendment? That's not deferring to the legislature at all. Or how do you explain what it's done with the campaign finance, striking down the bipartisan finance campaign finance act and saying that corporations are to spend unlimited amounts of money? That's not being restrained. Or how do you explain Shelby County versus Holder, striking down a key provision of the Voting Rights Act? The court is not being restrained and deferring to the legislature. It defers to the legislature when it likes what the legislature is doing and overrules when it doesn't. And this is true of both liberal justices and conservative justices, where they disagree as when to defer to the legislature. Let me compare two examples. And they both came down in June of 2013. On one day, June 25th of 2013, the court decided Shelby County versus Holder. And it's a 5-4 decision, striking down the key provisions of the Voting Rights Act that said that jurisdictions with the history of race discrimination had to get pre-clearance before changing their election systems. And the 5 conservative justices are in the majority. Justice Ginsburg writes one of the most famous dissents saying, we need to defer to Congress in its judgment. Congress held 16 hearings, 10,000 pages of legislative history, court should defer. The next day, Wednesday, June 26th, decides Obergefell versus Hodges. and the Supreme Court strikes down a key provision of the Defense of Marriage Act that says for purposes of federal law, marriage has to be between a man and a woman. 5-4, and the liberal justice in the majority, the dissenting justice is vehemently disagreeing. I'm sorry, it's United States versus Windsor was the 2013 case, the day after Shelby County. 5-4, and the conservative justice all saying, we should defer to Congress here. Only Justice Kennedy was in the majority in both cases. What's the difference between the two? It can't be explained by judicial restraint versus judicial deference. The only difference between the cases is the value of the justices. And that's how we have to understand the court. And right now, you have to understand it is 6 individuals who are very conservative and much more conservative than the median American voter.
If I could just address that. And one thing we have to keep in mind when evaluating the court, especially since we're thinking about it in terms of its role in history, is compared to what? Right? It's certainly the case that this court, like every court for the last 150 years, sometimes strikes down statutes, sometimes overturns precedent. My point is that it does both of those things significantly less often than its predecessors. Dean Chemerinsky early talked about having to revise his casebook. Talk to folks that taught criminal procedure in the 1950s and 60s, and how often they had to revise not just their syllabus, but like what they were teaching the next day. Talk to folks that taught state and local government law during that same period. Again, setting aside whether we like or dislike the changes that the court made, in terms of the court overriding the political process and striking down statutes and overturning precedents, it was doing that far more often than it does today. Whether or not that trend will continue, interesting question, but if that's the basis of how much we want to evaluate the court, it's doing less of that. Even in a context like the Second Amendment, prior to the 21st century, there was maybe one Supreme Court case on that question. I say maybe because there are different ways of reading the Miller decision and whether or not it squarely addressed the question of what the Second Amendment and the 14th Amendment protect with regard to gun rights wasn't really before the court. And if the court wanted to be really aggressive in that area, it wouldn't have only heard 4 cases on this question in the last 20 years, but that's all it's done. The 4th one will be this term, when there is clear text, not only in the Second Amendment, but also a very clear history about the importance of gun rights during the adoption of the 14th Amendment, when it was recognized that gun rights were absolutely essential for Black Americans to be able to protect their own freedom, particularly in parts of the country where they could not depend upon the protection of the state. And if one goes back and looks at the ratification of the 14th Amendment, there's no question. We might agree about the understanding of the Second Amendment as the limitation on the federal government in 1787. I don't think there is any room for disagreement on the importance of the ability to protect oneself with a firearm as a privilege or immunity of citizenship under the 14th Amendment, and there are quite a few historians who have done extensive work on that. In terms of values, it's certainly true, as we've already noted, that the values of the justices will influence their decisions, which is why I think it's important to think about whether we want a decision where a political coalition that gets to put a majority on the court gets to have its values overriding legislative process, or whether we want less of that, because that is part of the choice that we face. And when the court overturns precedent, when it strikes down statutes, there's no question that the court is much more consistent in the ideological valence of those decisions than it was before. Dean Chemerinsky mentioned Justice Kennedy. When he was the median justice on the court, whether the court tacked left or tacked right in any given case that was really high profile was really a question of what did Justice Kennedy think, which basically meant First Amendment cases the government almost always lost, and in every other context it was kind of whatever Justice Kennedy's particular judicial philosophy meant. Today, those cases all go in one direction. That's certainly a significant difference in the sense of the ideological uniformity of those decisions given the issues that are coming before the court. But it's not a question of the magnitude in terms of the number of cases where that's happening. And again, if that's a difference, if that's something we don't like, well then that's certainly something that there's room in the political process to address. But overall, I think it is significant that the court is doing that sort of thing less often.
When it comes to the question of abandoning precedent, Justice Kagan has written that precedent is not an inexorable command. And Brandeis once famously observed that it is more important than the law be settled than that it be settled right. You can think about that one for a long time, but walking away from precedent is a big deal. And it has been known to be the case that people love stare decisis when they agree with the outcome, and they can't wait for it to change when they disagree. So what principles, gentlemen, should guide judges when they are considering walking away from what has been settled precedent for a fair amount of time in the Republic? What are those principles, Erwin?
The point that I was making with regard to precedent, unless you correctly, is you can't explain what the Roberts Court is doing by saying, oh, it's just following precedent. And the problem that I have with Professor Adler's statistics is that they don't account the significance of the decision. Overruling Roe versus Wade, overruling the affirmative action cases, overruling the test with regard to the Establishment Clause, or I give examples of overruling major First Amendment precedents, are so significant for our society. And I think that in terms of principles, there are long articles and books written about precedent and stare decisis, and they all come to the same conclusion. Precedent should be followed except when it should be overruled. And of course that's right, because we all believe that precedent matters because it provides stability and predictability in the law. We all believe there's times when precedent must be overruled. It was essential that Brown versus Board of Education overruled Plessy versus Ferguson. The Supreme Court has articulated criteria. Has the precedent proved unworkable in practice? To what extent has there been reliance on the precedent? How much will overruling the precedent disturb that reliance? And we could come up with criteria like that, but I don't think that the court overruling Roe had anything to do with those criteria. It was just that Donald Trump got to pick 3 justices to join 3 conservatives who were there. And therefore, they had 6 justices to effectively overrule Roe. Only 5 actually voted to overrule Roe. The court didn't overrule Bakke and Grutter and Fisher for affirmative action because of any principles with regard to stare decisis. They did so because Donald Trump got to pick 3 justices. The court didn't overrule the Lemon test with regard to the Establishment Clause because of any criteria, but because they had 6 justices to do so. And I don't think we should pretend it's anything other than the very conservative ideology was on the court.
It's certainly the case that the reason that Roe and Bakke were overturned was because there was a conservative majority on the court. I don't think there's any question about that. In terms of what the court should do, the court since the very beginning, since the very first precedent that was overturned, and now the name of that case is going to escape me, but it's an admiralty case. Chief Justice Marshall dissents on the grounds that it's more important that the law be settled than it be correct, and arguing that the court should not lightly overturn precedent. So this debate has been with us since the very first time the Supreme Court overturned one of its own precedents. My own view is it should generally be done rarely. It should generally be done only when the precedent is unworkable or is profoundly wrong. I think if you were to ask the justices that voted in the majority in Students for Fair Admissions or Dobbs, they would, in good faith, argue that in both those cases, they saw the precedents that were being overturned as being both profoundly wrong and unworkable or corrosive in terms of the broader fabric of our law. Are there grounds for disagreeing with them on those points? Sure. These are hard questions about which reasonable people in good faith can disagree. But this is not a court that just throws out a precedent every time someone raises a question about whether a decision was initially correctly decided. There's only one justice on the current court, Justice Thomas, who has argued that the court should always overturn a precedent that is inconsistent with the original public meaning of the text. His argument is that justices take an oath to the Constitution, not to the court's prior precedent. And so in every case, when called upon to answer the constitutional question, fulfilling their oath requires that. But that's an outlier. Every other justice thinks that there's a balance of factors. And we have seen cases in which some of the conservative justices on the current court have raised concerns about whether or not to overturn precedent based on what this would do to settled expectations, what this would do to the fabric of the law, and Justice Barrett has raised this on a couple of occasions, what would replace the precedent, right? Because a given rule of law might not be great. it might be in tension with what we think the text is, but after a certain amount of time, we know what to do with it. We know how to apply it. We know how to articulate the test. We know how to think about how that might cash out in certain sorts of circumstances, and it's very hard to just suddenly wipe it away. I think it's significant that when we think about the cases overturning prior precedent, the most significant ones in the Roberts Court, these weren't questions that were new. These were questions that jurists and legal scholars have been arguing over and fighting over for decades. I think what's really interesting and what will be a real test of this court going forward is whether or not it is equivalently aggressive in questions that are new. And what I believe, and I'm always hesitant to make predictions when I'm on stage with Dean Chemerinsky. A few years ago, I made one prediction that was profoundly wrong about the DACA case when we were at a panel at Irvine. But I think the current court is going to be less likely to overturn precedents about questions that are still emerging, where it's not clear about what would replace the law we have. And I think that's what we want justices to do, because I think justices should have a degree of humility, both about overruling the actions of the political branches, especially the legislature, as well as about second-guessing the accumulated wisdom that's embodied in precedents of prior courts.
You've been so restrained. I've been watching you. Of course you can.
I want to talk one anecdote which I think responds to Mr. Adler, and it's a case that probably most people haven't heard of. It's a case decided by the Supreme Court a few years ago, Franchise Tax Board versus Hyatt, and I mention it because it's a case that I argued in the Supreme Court. In 1979, in Nevada versus Hall, the Supreme Court held that a state could be sued in another state's court. So in this instance, it was somebody in Nevada suing the state of California for truly egregious harassing behavior, so much so that the jury awarded this person $380 million in damages. By the time it came to the Supreme Court, it was about worth $1 million. And the Supreme Court granted cert on one question: should Nevada versus Hall be overruled? Now, there were only a handful of cases that had ever come up since 1979 where a state was suing another state. So it wasn't as if this proved impossible to administer in practice. It wasn't a high-profile area like the ones that you're talking about. It wasn't like there was some new discovery of a musty history of the Constitution. But the Supreme Court, 5-4, overruled Nevada versus Hall with the 5 conservative justices in the majority. Justice Breyer, in his dissent, said there's got to be a better reason to overrule precedent than the current majority would have decided the case differently. And he then concluded in a way that was prescient. He said, we can only wonder what other precedents are now likely to be overruled.
All right, so let's talk about the role of public opinion. Professor Barry Friedman posits that once the court decides a constitutional issue, that's when the work of democracy really begins. There's a consequential decision. The public reacts positively, negatively, sometimes not very much at all. Maybe the Congress will get involved, maybe they won't. But both Justices O'Connor and Ginsburg have said that real change, when it comes, is a development that stems principally from attitudinal change in the public, from an emerging social consensus. Professor Friedman said something very interesting when he wrote that the central function of judicial review today is to serve as a catalyst for people to think seriously about the Constitution. That's kind of a very different take from what most of us learned in law school. The Supreme Court decides something, it finalizes an issue. We don't usually think of the Supreme Court as a catalytic source of activity. What do you think, Jonathan?
Well, I think there's a lot to what Professor Friedman has said in his writings on this subject. I mean, certainly we know in terms of the facts on the ground, the political branches and Congress in particular often matters a lot more than the courts do. And when a court decision really cuts against what political powers want to be able to do, especially if it's striking down statutes or declaring certain arrangements to be unconstitutional, the effects of that aren't going to materialize as rapidly as when what the court is doing is essentially reifying an emerging consensus. So one can just look at the protracted conflict over school desegregation after Brown and how on the ground what really made the big difference was the federal government getting involved, both in terms of legislative action, use of the spending power, but also the ability of the Department of Justice to litigate rather than leaving cases to families that were willing to go to court to challenge school segregation. But comparing that to, say, Obergefell, where public opinion had been changing so dramatically, it's one of only 2 or 3 issues in American history where we've seen public opinion change as dramatically as quickly as it did. The two that are at the top of that list are views towards same-sex marriage and views towards marijuana legalization, where we just see within generations, as opposed to it being a purely generational change, public opinion changing very dramatically. When the court's making a decision in line with that sort of shift, it'll be almost as if the court did very little at all. When the court's pushing against that, the question is whether or not the political process will get involved. In terms of being the catalyst, I think we're at a point right now where it would be very interesting to see, because a lot of the court's decisions, especially pushing back on executive power, have the underlying message of this is Congress's job. How to deal with climate change, this is Congress's job. Right? That's the message of a case like West Virginia versus EPA. Don't dust off a statute that hasn't been revised in 30 years and find in it some new powers or some new ways of regulating industry. Get Congress to get back in the game of actually updating these laws like it used to do every several years. Right? It was common for environmental laws to be updated every 6 or 7 years. We haven't updated the Clean Air or Clean Water Act in over 3 decades. Ideally, those sorts of decisions would be a political catalyst, right? To say you can't just expect a president with a phone and a pen to just take control of these issues. It's something that we, the people, have to push our legislative representatives to act on. And one test of Professor Friedman's thesis might be whether or not on issues like climate change, like issues related to the internet and the like, the political process does fill the void that is being created by certain court decisions.
What the Supreme Court does often affects people in the most important and intimate aspects of their lives. Those decisions can also then be a catalyst for political discussion and political action. But I think it's a mistake to say the decision's primary effect is a catalyst. The primary effect is often what it means for people's lives. And the role as a catalyst follows from that. You mentioned rightly the Supreme Court's decisions in Brown following Brown. Those made an enormous difference in our society and ultimately led to the end of Jim Crow laws, but they were also a catalyst for public change. Sometimes, though, the Supreme Court's decision cuts off the ability of the political process to act. Think about what the Supreme Court did in Citizens United. The ability of Congress, the ability of state legislatures to adopt campaign finance reform was enormously limited. Think about affirmative action. Up until June 29th of last year, it was left to the political process. Some states like California and Michigan and Washington and Arizona, by state constitutional amendments, had abolished affirmative action. Other places allowed it. The Supreme Court slammed the door on the political process by saying that no jurisdictions are able to do it. Or an example we haven't talked about but fits in terms of this is a court that doesn't respect precedent, case from a few years ago, Janus versus American Federation. The Supreme Court in 1978, in Abood versus Detroit Board of Education, said that a state can require that non-union members pay the share of the union dues that support the collective bargaining activities of the union, so individuals couldn't be a free rider. About half the states went ahead and did that. Other states prohibited. The Supreme Court slammed the door on that, saying, under the First Amendment, no state can require non-union members to share the dues to support political activities. So in that sense, the court isn't serving as a catalyst. It's cutting off political discussion. And when we think about the relationship of public opinion in the court, we have to also focus on abortion. 2/3 of the American people believe that Roe versus Wade was rightly decided. 2/3 of the American people believe the court was wrong in Dobbs, but that didn't matter to the justices.
If I could just jump in there, invoking Dobbs is really interesting here, right? Because first of all, I'm not sure 2/3 of Americans could have actually accurately described precisely what Roe held, the trimester framework, what was still allowed under Casey in terms of what states could enact and not enact. let alone what the effect of Dobbs is. But in terms of a catalyst for democratic activity, Dobbs has certainly been that. In my own state of Ohio, a very red state, reproductive rights have greater protection now than they did prior to Dobbs, because we adopted a constitutional amendment through the political process in the state of Ohio that is far more protective of reproductive rights than the Supreme Court's Casey opinion had been and the legislation that had been enacted under Casey in the state of Ohio. We are now seeing in states the political process enact laws that reflect the views of people in different states, and we are learning from that. I mean, and we are learning what the consequences are of certain laws that may sound good in theory, but what do they actually look like on the ground? And if one looks at an area like abortion in the United States versus Europe, we see the issue being far more polarized in the United States, in part because that democratic process of figuring out how to reconcile these very powerful competing values that different people have and how to enact laws that reflect some degree of compromise on those views was cut off here, where it had been allowed to proceed in the intervening decades in much of Europe. I actually probably disagree with aspects of the Students for Fair Admissions holding, largely on the same sorts of grounds. I'm not convinced the 14th Amendment forecloses the political process from considering race as broadly as the Supreme Court does. But in both cases, my view is if we want the political process to operate, you got to be willing to say the court is not going to, especially if there's not a textual basis for it, declare certain outcomes off limits, and rather allow the political process to do that. And if we enact laws that we decide are really terrible, then we will learn from that and we will change accordingly. It shouldn't simply be my political coalition gets to adopt the laws that infringe upon liberties that my political coalition likes, but the other political coalition can't. And I think if we view the court as playing that role, its ability to safeguard a lot of very important textually grounded values, particularly things like the protection of criminal defendants, are the sorts of things we're going to lose. Because you put those sorts of things up to a vote, they're not going to do so well. And yet they were essential in our founding period. They are written in the document. If we want the court to be able to defend those things, we want it to be more circumspect about how often it takes things out of democratic hands. And I say that as someone, again, who wishes legislatures did a lot less than they do. I'm just not convinced that the Constitution, as it's written and as our process is structured, it rightfully empowers the courts to take those questions out of the political process.
What underlies this discussion is, what are the rights that are so important that we shouldn't leave them to the political process? And with regard to abortion, I think it is a tragedy that the political process in states like West Virginia, Indiana, Oklahoma, Alabama have completely prohibited abortions from the moment of conception, except to save the life of the pregnant person. Why is that? Because the Supreme Court has rightly recognized that there are aspects of privacy and autonomy that should be protected from the political process. The court did that long before Roe. That laws that prohibit abortion infringe the ability of people to make those decisions for their lives. And countless individuals are going to suffer with unsafe back alley abortions or unwanted children because the Supreme Court took away a fundamental right. So you're absolutely correct. The question is, what are those rights that the court should protect in the political process? And I unequivocally believe that Roe versus Wade was right in protecting women and their choices with regard to their bodies.
I want to ask a follow-up question to your slamming the door notion. It's very interesting that a year before she went on the high court, Justice Ginsburg wrote that, in her view, when Roe was decided, the country was gradually moving towards a more permissive view on the abortion question. But she suggested that Roe actually prolonged divisiveness on the topic and made it more difficult for us to have a settled understanding of the law. And I think it's very interesting that that should be Justice Ginsburg's view. What's your take?
Yeah. There's scholarship by Reva Siegel and Linda Greenhouse that says exactly the opposite. That in 1973, when Roe was decided, only 4 states had legalized abortion. Of the other 46 states, about half prohibited all abortions, and half had adopted the model penal code approach, which had exceptions for abortion in cases of rape or incest to save the life of the woman. There's no indication that there was a trend towards legalizing abortion. But even if there were, if you believe that there is a right to abortion, as I do, that it's not something that should be left to the political process. And I think of the 2 million women a year who are able to have safe legal abortions because of Roe, what would have happened without it? The other interesting thing was Roe wasn't politically controversial when it was decided. Richard Nixon was president. He didn't speak out against it. The Republican platform didn't condemn it in 1976. It was only when Ronald Reagan was running and wanted to enlist the moral majority that Republicans became anti-abortion. So I think we have to look at a much more nuanced history than that one.
And you have 90 seconds.
I would say I think that one thing we are lacking in our politics today, and I think Roe in some respects encapsulates this, is the inability to sit down with people that have very different views than we do and come to political compromises that can be stable. And I think on a wide range of subjects, when the court takes issues out of the political process, it reduces our ability to, as citizens, deal with each other and cross these divides and reach resolutions that will leave none of us perfectly happy. And my hope is if the court continues on its current trend, we will regain that muscle memory about how to deal with contentious issues in a divided country, because we can't let the judges decide all these questions.
Ladies and gentlemen, it has been quite an interesting afternoon. And we could spend a whole lot more time, and probably will as we exit this auditorium, or you exit wherever you are watching on television. I want to thank our panelists for their very insightful discussions. I want to thank the audience for your questions. I'm sorry we didn't get to more of them, but hopefully we at least touched on some of the topics in which you were interested. And our time has come to a close, and we are in adjournment.